I'll now read the judgment of the court. Please be advised that shortly after the hearing is complete, you will have a copy of the judgment by email. Introduction. The applicant, Ms. Senga Jones, deposed that she is a citizen of Guyana who was a registered voter and who voted at the March 2nd, 2020 national and regional elections. She is supported in her application by Ganesh Mahipal, who deposed that he was an accredited counting agent for the APNU-AFC at the elections and participated in the recount process, the declaration of the results of which are the subject of challenge in this application. As is well known, the national and regional elections took place on March 2nd, 2020. The post-election day storm, to which I referred in my judgment of March 11, 2020, in Holodar and the returning officer Mingo and others, has not as yet calmed. Over the past 4 months, there have been continuous contentions and contestations as regards the results that should be relied on by the first respondent, the Guyana Elections Commission, GECOM, in order to declare a winner, and by extension, the President of the Cooperative Republic of Guyana. After the Holodar case, the returning officer for District 4, about whose declaration it is common knowledge there is the most contention, made a declaration of the results of this district on March 13, 2020. This completed the declarations for the 10 electoral districts. Subsequent to the Holodar judgment, and during the pendency of contempt proceedings against the returning officer for District 4, a decision was communicated by the chairperson of GECOM in court on the said March 13, 2020, that a recount of the votes cast at the elections would be conducted, no doubt to assuage the contestations. It was soon thereafter revealed that President Granger and the leader of the opposition, Mr. Bar Jagdio, agreed to a recount of the votes cast, then stated to be under the supervision of CARICOM. This recount agreement was challenged in Moore and GECOM, FDA 394 of 2020. I'll refer to it hereinafter as Moore, which ultimately engaged the attention of the Court of Appeal, which rendered a decision on April 5, 2020. Following the Moore decision, GECOM issued Order 60 of 2020, which I'll refer to as Order 60. Order 60, which was made pursuant to Article 162 of the Constitution and Section 22 of the Election Laws Amendment Act number 15 of 2000, permitted the recount of the votes cast in all 10 electoral districts and a declaration to be made of the final credible count. According to the order, the recount was to be undertaken, executed, and supervised by GECOM and scrutinized by CARICOM. The third respondent, CEO of GECOM, presented a report on the recount results of the elections to GECOM on June 13, 2020. As a consequence, on June 16, 2020, the chairperson wrote the CEO requesting him to prepare and submit a report by June 18, 2020, based on the recount results pursuant to Article 177(2)(b) of the Constitution and Section 96 of the Representation of People Act. Before the CEO could submit this report, another application was filed. This application, Eslyn David and Chief Elections Officer, Civil Appeal number 41 of 2020, was made to the Court of Appeal pursuant to Article 177(4) of the Constitution. In a majority decision, the Court of Appeal held that in ascertaining the votes cast for the purposes of Article 177(2)(b), declaration of the President, GECOM had to rely on valid votes cast. Justice Reynolds, who agreed with the decision of Justice of Appeal Gregory, further held that Order 60 created a new electoral regime which established separate elections, one for the presidency and the other for the National Assembly. Justice Rishi Prasad dissented, in some holding that the application was misconceived. The 7th and 8th respondents herein, who had been joined in that application, were dissatisfied with the decision of the Court of Appeal and appealed to the Caribbean Court of Justice. The CCJ rendered a decision in Ali and Jacques and David on July 8, 2020, overturning the majority decision of the Court of Appeal and nullifying a report with elections results that the CEO had submitted on June 23, 2020 to GECOM during a 3-day stay of the Court of Appeal decision. Subsequent to the decision of the CCJ, on July 9, 2020, the chairperson again wrote the CEO requesting that he submit an Article 177(2)(b) and Section 96 report on the election results based on the Order 60 recount. The CEO did not comply with this request. After further correspondence between the chairperson and the CEO, he finally submitted a report on July 11, 2020, that was not based on the recount results, but apparently based on the 10 declarations submitted to him by the returning officers pursuant to Section 84 of the Representation of the People Act, the RPA. On July 13, 2020, the chairperson issued a ruling in which she stated inter alia, and I quote, "The CCJ did not determine that a final credible count could not be established, neither did it set aside Order 60. The intent of Order 60 was to determine the final credible count by recounting all the ballots cast on the 2nd March from the boxes. Clause 14 of the recount order provides that the Commission can make the declaration from the final credible count of the results. It is my decision that the results of March 13 declarations cannot be used at this time, since these were replaced by the tabulation of the votes at the recount process, which was hailed by all to be a transparent and credible process," end quote. The chairperson again requested the CEO to prepare a report by July 14, 2020, based on the recount results. Then this application was filed by Ms. Jones. Applicant's contentions. The applicant in brief contends that Section 22 of the Elections Laws Amendment Act, pursuant to which Order 60 was issued, is unconstitutional. She also contends that as a consequence, Order 60 is invalid, and as a further consequence, that the recount results flowing therefrom are invalid. As such, she is stating that Order 60 is unconstitutional. She relies on the CCJ decision in Ali, stating that the CCJ nullified Order 60 and relied on the RPA in arriving at its decision that the Court of Appeal had erred in concluding that it had jurisdiction to hear the David case. It is contended that there has been a violation of Section 84(1) of the RPA by GECOM by its refusal to accept the declarations of the returning officers made pursuant to this section. She deposed that these declarations, which were all submitted to the CEO by March 13, 2020, when District 4 was declared, are still extant and valid. She urges that these declarations should and must be the basis for any declaration of the winner of the elections, and by extension, the declaration of the presidency. It is her assertion that the chairperson and GECOM cannot refuse to act on the CEO's report in this regard, nor can he be directed to utilize the recount results for the purposes of a final declaration of the election's results. Her application is supported by the 3rd and 4th respondents, the CEO and Attorney General, respectively. And then I outline the 28 claims for relief that the applicant has sought. The industry of all counsel is acknowledged. I mean no disrespect in not detailing the submissions made. As I did in Holidar, I note that there is much by way of evidence, whether substantiated or not, that has been placed before me in the affidavits as regards how votes were or were not counted, whether or not policy decisions and criteria were consistently applied to ascertain the results each is contending for, and referring to statements made by persons or entities, both local and overseas, with or without supporting exhibits as regards their views on the election's results. Apart from the factual matrix necessary to provide a background to this application, which I have outlined above, none of this information or material is relevant to a determination of this case. Further, affidavits that were filed or exchanged without the permission of the court are struck from or are not part of the record and have therefore also not been considered. Issues to be decided. Having reviewed the order sought, this application is really a challenge to the constitutionality of the recount process that was undertaken by GECOM pursuant to Order 60. As such, at the Case Management Conference on July 15, 2020, the parties were directed to make written submissions to be heard on the following issues. 1, whether this court has jurisdiction to hear this application. 2, whether Section 22 of the ELA, pursuant to which GECOM issued Order 60, is constitutional. 3, whether Order 60, and by extension the recount results obtained therefrom, are valid, such as to permit a declaration of the March 2nd, 2020 election results based on the said recount results. 4, whether the declarations of the returning officers for the 10 electoral districts made pursuant to Section 84 of the RPA should be acted on or be set aside. And 5, whether these issues are res judicata given the decisions of the Court of Appeal in Moore and the CCJ in Ali. The first issue, whether this court has jurisdiction to hear this application. I understand the gravamen of the complaints by the applicants, supported by the CEO and the Attorney General, to be that the chairperson and GECOM have not complied with their public duty as outlined in Article 177(2)(b in relation to the declaration of the elections and consequentially the declaration of the president, and that in so doing they have sought to nullify Section 84 of the RPA. In this regard, they are acting outside the Constitution and the RPA in an election process that is still ongoing, and that therefore their actions are subject to judicial review. The applicant seeks to have Article 177(2)(b interpreted because, as submitted on her behalf, an impasse now exists between the chairperson and the CEO as to which results are to be used in order to declare the election. In this regard, it is contended that the chairperson is obliged to accept the report and advice of the CEO in relation to the declaration of the results. It is submitted that this impasse must be resolved now and cannot await an election petition. In this regard, the issue is whether the chairperson and GECOM must accept whatever the CEO produces for their consideration as regards the results of the elections. On behalf of the CEO, it is submitted that GECOM, and more particularly the chairperson, are acting in breach of their constitutional and statutory powers in refusing to act on the basis of the report prepared by the CEO, pursuant to Section 96 of the RPA, as the chairperson is constitutionally bound to do pursuant to Article 177(2)(b, and as such that judicial review can go to ensure that the chairperson complies with Article 177(2)(b. Citing paragraph 42 of the preliminary point judgment in Holidar, dated March 8, 2020, counsel for the AG submitted that this is a case where the court's supervisory jurisdiction can be invoked to ensure the correct and smooth operation or progress of the elections, proceedings, or process. It is submitted that the proviso to Article 226(7) of the Constitution excludes GECOM from the provisions of Article 226, which ousts the court's jurisdiction to inquire whether constitutional commissions have validly performed their functions. As a consequence, the proviso permits the court to inquire whether the chairperson and the GECOM are acting lawfully in the context of this case. I, however, prefer the counter-argument that the proviso to Article 226(7) states that even though GECOM is exempted from the operation of the ouster clause in Article 226(6), this is without prejudice to the power of Parliament to make provision in relation to the functions of GECOM. Parliament has done so by Section 140 of the RPA, which provides that apart from an election petition as provided for in Article 1 of the Elections Commission or any of its members has been performed validly or at all, shall be inquired into in any court. The applicant, supported by the AG and to some extent by the CEO, also contends that Section 22 of the ELA is unconstitutional, and therefore Order 60, made pursuant thereto, is unconstitutional and therefore invalid. This, they contend, must be addressed by this court. This is a substantive issue to be determined in this decision, and I will return to this. I note the submissions on behalf of most of the other respondents that this court has no jurisdiction to entertain this application. They argue that the issues she raises speak to an election dispute and are best dealt with pursuant to Article 163 by an election court pursuant to an election petition. Section 140 of the RPA is also relied on. However, it is submitted on behalf of the 5th and 6th respondents that this court does have jurisdiction, albeit limited to where GECOM has acted or is about to act in excess of its constitutional and or statutory powers. In Holodar, as noted by the applicant in her submissions, I held in paragraph 33 of the preliminary point judgment as to jurisdiction that this court has jurisdiction to hear an application regarding whether a person exercising authority has complied with her or his statutory duties. I relied on the cases of Norton and Hamilton in so concluding. The chairperson is a person with constitutional authority as granted in Article 177(2)(b) of the Constitution. Similarly, GECOM has powers under Articles 166(1)(a) and 162 of the Constitution and the RPA. As regards the chairperson, I note the dicta of Chief Justice Bernard, as she then was in the Norton case, where Her Honor acknowledged that, but for the specific ouster of the court's jurisdiction to question the decision of the chairperson of the Elections Commission to declare the presidency pursuant to Article 177(6) of the Constitution, the court had jurisdiction to order certiorari against the decisions of the commission and its chairperson. Justice Bernard clearly emphasized that the court can exercise a supervisory jurisdiction in elections cases outside a challenge to the validity of the elections by way of election petition. More importantly, in Moore, the Court of Appeal by majority overturned the full court decision that the ouster clause in section 140 of the RPA precluded any inquiry into the decisions of the chairperson and GECOM. The Court of Appeal held at paragraphs 84 and 108 that where GECOM has acted or is about to act outside of its powers, that it will be subject to the supervisory jurisdiction of the court. I am cognizant of the restrictions imposed on the court by Section 140 of the RPA and by Article 163 that would require an approach to the court by way of election petition. However, in the peculiar context of this case, where there is an impasse regarding the decision-making of GECOM to complete the elections process, and it is necessary to advance this process, which is still in progress, judicial review is necessary to address this impasse. I am of the view that the applicant is really seeking the interpretation of the Constitution for a determination whether the chairperson, GECOM, and the CEO are acting lawfully. It is in this context that there can be judicial review of their decisions. I have further concluded that in this context, there is a distinction to be drawn as regards inquiring into the functions of the chairperson and GECOM, which is restricted by Section 140, and interpreting the constitutionality of Section 22 and Order 60, as well as Article 177, to determine if they are acting lawfully, albeit these provisions speak to the powers and functions of the chairperson and GECOM. Thus, on this narrow basis, it is an inquiry into the legal framework that guides the carrying out of their functions to complete the elections process. If the legal framework is found to be unconstitutional and therefore void, then their functions and actions would perforce be affected. Applying my decision in Holidar and the Court of Appeal decision in Moore, by which I am bound, I hold that this court has jurisdiction to hear this application. Having so found, I now move to the second issue for consideration, which is whether Section 22 of the Election Laws Amendment Act number 15 of 2000, pursuant to which GECOM issued Order 60, is constitutional. The applicant, the CEO, and the Attorney General state that Section 22 is unconstitutional because it confers lawmaking powers on GECOM, a non-legislative body, in contravention of Article 170 of the Constitution. Article 170 provides for Parliament to be the lawmaking body. More specifically, it is pointed out that Article 160 gives Parliament the power to enact laws with respect to the electoral system. It is argued that Parliament cannot transfer or delegate this power to another entity, and that in this case, in conferring on GECOM an arbitrary lawmaking power, it has abdicated its lawmaking power. In this regard, the enactment of Section 22 offends the separation of powers, more especially as it permits GECOM to amend laws even when Parliament is dissolved. In addition, the Attorney General submitted that Section 22 was utilized to produce Order 60 in order to amend Article 177(2)(b) in violation of Article 164, which provides for how the Constitution is to be amended. Order 60, it is contended, purports to strip the CEO of, quote, his constitutionally indispensable advisory role, end quote. This advisory role, as mandated by Article 177(2)(b), means that his advice is to be tendered to the chairperson based on the information from the returning officers of the 10 electoral districts, and that a declaration of elections results must be made pursuant thereto. The responses of the other respondents are based on two limbs. Firstly, that Section 22 is not unconstitutional, as it did not give GECOM an unfettered discretion to act. It is urged that it is limited in its scope. It is only where difficulties arise, excuse me, in the application of the specified legislation that GECOM is entitled to make provision as necessary and expedient for removing the difficulty. And further, while GECOM is given the power to amend legislation, the period within which this can be done is only for 3 months after the elections. And when Parliament is not dissolved, the power is subject to negative resolution. The power delegated to GECOM being so narrowly prescribed means that the scope of the power was carefully considered by Parliament. In this regard, Article 162 permitted the enactment of Section 22, as the article gives wide powers to GECOM in relation to the conduct and administration of elections to ensure impartiality, fairness, and compliance with the provisions of the Constitution or of any act of Parliament on the part of persons exercising powers or performing duties connected with or relating to the matters aforesaid. It is submitted that given the circumstances of difficulty which have occurred in these 2020 elections, GECOM was lawfully empowered to issue Order 60. It is contended that even the applicant in her affidavit recognizes that difficulties have arisen. These GECOM must address. It is submitted that in any event, Order 60 does not amend any legislation. Secondly, these respondents highlight that this issue is res judicata, as the Court of Appeal has pronounced in Moore on the court's ability to inquire into the constitutionality of Section 22. It is this second submission that commends itself to me. Thus, the answer to this question, in my view, poses little difficulty given the decision of the Court of Appeal in Moore. The Court of Appeal identified the constitutionality of Section 22 as an issue in the appeal. The Court of Appeal clearly held at paragraphs 106 and 107 that they agreed that the legality of Section 22 was a matter to be frontally examined by the court at a full hearing. The court considered the decisions of Petrie and Sikumar Singh and noted and held at paragraph 106 that the High Court declined to examine the constitutionality of election-related legislation during the election period, allocating such questions to an election petition. The court said that such a determination would be disruptive of the electoral process. Moreover, it is well established that constitutional questions can be determined in the hearing of a petition, as discussed in Peters and Chaitan. It was further held by the Court of Appeal at paragraph 107 that if GECOM had utilized or utilizes its powers under Section 22 unlawfully, then this would be a question for determination at such time, and that no sufficient evidential basis exists for such a determination at this point. As such, the submission on behalf of the applicant that the Court of Appeal's decision on Section 22 is obiter dicta when it is based on similar arguments as advanced before this court cannot be accepted. And even honors discussion of the effect of such judicial pronouncements in the case of Ying and Song, it has long been the case that the weight accorded to obiter dicta will vary depending on the circumstances in which those dicta fell, and that considered dicta of appellate courts, though not strictly binding on courts in lower or equal position within the judicial hierarchy, must be afforded great weight and should be departed from only with the greatest of caution, end quote. But the decision of the Court of Appeal on Section 22 cannot be considered to be obiter dicta or a passing statement or comment. The pronouncement of the Court of Appeal was a definitive and considered finding based on a point that was clearly argued. I am bound to give it judicial weight as being part of the ratio decidendi or reasoning of the court rather than obiter dicta. The Court of Appeal, having found that a challenge to the constitutionality of Section 22 would be for an election petition, the principles of res judicata apply. So the issue having been raised and importantly dealt with by the court, it cannot be canvassed again. And even more importantly, since it is a decision of an appellate court, sitting as I am in the High Court, I am bound to follow this decision. I can discern no distinguishing feature that would permit me to depart from this judgment, nor has any evidence been disclosed on the affidavits by and or on behalf of the applicant, such as to permit me to do so. The third issue, whether Order 60 and by extension, the recount results obtained therefrom are valid, such as to permit a declaration of the March 2nd, 2020 election results based on the said recount results. This issue requires more in-depth consideration and really is the heart of the applicant's application. A determination of this issue in her favor would mean that most, if not all, of the relief sought could be granted. The submissions of the parties invite an interpretation of the CCJ decision in Ali. The applicant hinges her objection to Order 60 primarily on the unconstitutionality of Section 22, which has just been addressed. The applicant also submits that the CCJ decision, more particularly at paragraphs 37, 45, and 52, lend to the view that the Apex Court nullified Order 60. The affidavit of and submissions on behalf of the applicant, the CEO, and the Attorney General in relation to this issue are rather nuanced. And here I've quoted from paragraphs 48, 49 of the applicant's affidavit and the paragraphs of the CCJ judgment to which she referred, that is paragraphs 37 and 45 and 52 of the CCJ decision. The applicant also referred to recital 8 of Order 60, which is quoted. It is submitted on behalf of the CEO that even if Section 22 is constitutional, Order 60 as subsidiary legislation overreaches as it gives GECOM power to recount votes that have already been declared final pursuant to Section 84 of the RPA. It is urged that GECOM cannot, by subsidiary legislation such as Order 60, give itself the power to resolve elections disputes which are for an election petition. In this regard, GECOM arrogated to itself the authority of an election court by invalidating the declarations. Therefore, Order 60 is unlawful. Reliance was placed on paragraph 52, as well as paragraph 46 of the CCJ decision. The AG submitted that Order 60 created a new regime, which is in tension with Article 177(2)(b) and Section 96 of the RPA, which provides for the CEO to ascertain the election's result by calculating the total number of valid votes cast from the declarations of the returning officers. The chairperson and the added respondents submitted that the CCJ did not invalidate Order 60. It is contended that when read as a whole, the CCJ decision confirmed Order 60. Further, it is submitted that the Court of Appeal permitted the recount by its decision in Moore. It is also pointed out that the David case was argued both in the Court of Appeal and on its appeal in Ali at the CCJ on the premise that Order 60 is valid. It is submitted that the CCJ decision is replete with references to Order 60, which are premised on its validity. It is stated that the CCJ has specifically reviewed and approved not just the recount, but the contemplation that the result of the recount will be binding and will be acted upon, and therefore any argument that somehow this recount cannot be used by GECOM is specifically rejected by a court which binds us. As a consequence, it is urged that this issue is also res judicata and cannot be inquired into by this court. I have concluded that an holistic review of the CCJ judgment in Ali supports the contention for the chairperson and the added respondents that this issue is indeed res judicata. Thus, the interpretation of the CCJ decision by the applicant, the CEO, and the Attorney General is hopelessly flawed. The CCJ judgment lends to the ineluctable conclusion that the recount votes are ex facie valid. Hence, the view expressed that any irregularities would have to be addressed via an election petition. Paragraph 37, which is relied on by the applicant, seeks to further explain what the CCJ described in paragraph 36 as a hybrid presidential system. The court explained that an elector's single ballot serves to determine both election of members of the National Assembly and also election of the president. This explanation has to be linked to the consideration of the decision of Justice Reynolds in the Court of Appeal, as referred to in paragraph 15 of the judgment, that Order 60 established a new elections regime in separate elections for members of the National Assembly on the one hand, and on the other hand, the election of the person deemed to be president. Paragraph 37 is clearly linked to a finding that this aspect of the decision of Justice Reynolds was not correct. Significantly, paragraph 37 cannot be read in isolation. This is so because immediately thereafter, in paragraphs 38 and 39, the CCJ explained Order 60 in detail, commencing with the opening statement that, quote, Order 60 relates only to the elections held on 2 March 2020, end quote. Importantly, the court went on to highlight that, quote, it was specifically introduced to cater for the various disputes and contentions that arose after polling day. The intention was to provide an open, transparent, and accountable recount of all the votes cast in those elections. The purpose was to assuage the contestations among the various parties, determine a final credible count, and remove certain difficulties or fill certain gaps in connection with the application of the provisions of the Representation of the People Act, end quote. After noting that the CEO was to supervise the recount process and that the aim at transparency included a variety of measures, in outlining the procedures for the recount as provided for in Order 60, the CCJ emphasized that, quote, Order 60 carefully set out how the process should unfold, end quote. And then I quote from paragraph 39 of the judgment. It is in this context that paragraphs 45 and 46 of the CCJ judgment have to be read. Therefore, the applicant's view that the letters from the chairperson to the CEO are invalid because they require him to produce a report based on the valid votes of the recount, which conflicts with the CCJ's explanation of valid votes in paragraph 45, has no merit. Indeed, in my view, this claim is another way of putting the claim made by Ms. David, which is recounted at paragraph 14 of the CCJ judgment, that, quote, the chairperson's 16 June directive to the CEO, who by section 18 of the Election Laws Amendment Act 2000 is mandated to be subject to the direction and control of the commission, require the CEO to commit an illegality, end quote. This is in the context that the June 16, 2020 letter, as quoted at paragraph 8 of the judgment, also requested the CEO to produce an Article 177(2)(b) and Section 96 report based on the results of the recount. In all this, the CCJ clearly considered the allegations made by Mr. Harman, an election agent for the APNU-AFC, as regards irregularities, voter impersonation, and fraud, and noted the concerns expressed by the CEO, commenting that he took it upon himself to present revised totals. I consider that this prompted the CCJ to make the comments or the findings that it did in paragraphs 40 and 41 of the judgment, which I quote. Therefore, which I have quoted, sorry. Therefore, far from nullifying Order 60 and the recount process, in my view, the CCJ explicitly endorsed it. It is clear from the above quoted part of paragraph 39 that the court was stating how the CEO was to conduct the tabulation, how he was to prepare his report for transmission to GECOM for its deliberation, and importantly, that such report would determine whether it would request the CEO to use the data compiled as the basis for the submission of a report under Section 96 of the Representation of the People Act. As regards paragraph 52, the CCJ, in my view, was simply saying that as subsidiary legislation, Order 60 could not be used to interpret the Constitution as the Court of Appeal had ruled, and that where there was tension or possible conflict between the subsidiary legislation and the Constitution, the latter would inform an interpretation of the former and not vice versa. The CCJ re-emphasized that Order 60 did not and could not create a new election regime. This was a clear reference to its finding as regards the decision of Justice Reynolds. The court did not, in explaining how any tension between the Constitution and subsidiary legislation should be treated, negate or nullify Order 60 either expressly or impliedly. And there is another reason why the applicant's contentions in relation to the recount cannot be upheld. In Moore, the Court of Appeal clearly stated that this would be an issue for a petition. The court concluded this in paragraphs 85 and 86 in relation to the recount, and I have quoted these paragraphs. And at paragraph 88, it was stated that, quote, whether the proposed recount is lawful are matters which would fall for determination under Article 163 of the Constitution, end quote. The fact that the Court of Appeal referred to the recount as proposed at the time does not negate from their decision as to what was to happen if one were dissatisfied with the recount. The completion of the recount cannot change this holding of the court. The Court of Appeal had before it the issue of the unconstitutionality of Section 22 and the recount. The Court of Appeal, in determining that it was, quote, in a position to exercise jurisdiction in its own right and to make orders it considers appropriate to dispose of the appeal, end quote, did not grant the injunction sought to prevent the recount. In effect, the Court of Appeal permitted the recount to proceed with the caution that it must be a GECOM controlled process. Then at paragraph 89 in Moore, the Court of Appeal went on to say that, quote, an election petition which has the features of a trial according to the procedures set out in the National Assembly Validity of Elections Act and rules would be the place for controversies central to the elections to be resolved by the High Court by way of evidence and cross-examination of witnesses. In that process, the court can also consider constitutional questions as part of its determination of any disputes before it, end quote. The evidence in this case at bar, as does the evidence as it appears from the judgment in Moore, reveals that there were and still are matters to be addressed by GECOM which relate to the execution of its functions under Article 177 and Section 99 of the RPA. The evidence, as in Moore, also reveals conflicts on issues that have to be addressed by GECOM. Hence, the conclusions of the Court of Appeal at paragraphs 85 and 86 of their judgment, as confirmed in their conclusion at paragraph 109. The affidavits in the case at bar clearly demonstrate that there are still matters in controversy. Thus, both courts by which I am bound have pronounced on this issue. This court, therefore, cannot rule that Order 60 is invalidated. This issue is therefore res judicata. The fourth issue, whether the declarations of the returning officers for the 10 electoral districts made pursuant to Section 84 of the Representation of the People Act, Chapter 103, should be acted on or be set aside. The applicant in her affidavit spoke to this issue in support of her contention that there must be reliance in the declarations of the returning officers at paragraphs 50, 51, and 54, which I have quoted. In light of her affidavit, it is submitted that the declarations of the returning officers for the 10 electoral districts, having been submitted pursuant to Section 84, they cannot be discarded and replaced. Thus, Order 60 could not permit new declarations. If it did, this was unconstitutional, as this order encroached on the jurisdiction of an election court under Article 163. The order also breached the RPA because the returning officers, as statutory officers, were excluded from the recount process. The latter assertion is an evidential issue that may be in controversy, and I do not rely on it. It is further advanced that Order 60 could not have retrospective effect, so as to nullify the Section 84 declarations made by the returning officers. The submissions continued that the returning officers were mandated to issue their directions pursuant to Section 84 of the RPA. Then the CEO was to consider them and prepare a report for GECOM pursuant to Section 96 of the said Act. These submissions were supported by those made on behalf of the CEO. It is submitted that Order 60, as held by the CCJ in Ali, could not institute a new legal regime for the declaration of the votes. Thus, the RPA had to be complied with, as Order 60 could not replace the requirements of this Act. Order 60 established a new regime for the determination of the validity of the votes by persons not authorized to do so. It was submitted on behalf of the CEO that Order 60 amended Section 84 by replacing the declarations with the recount as the source of the result. The AG submitted that the nullification of the 10 declarations can only be done by way of election petition, and he relied on paragraph 46 of the CCJ decision in Ali. My conclusions as regards the interpretation of the CCJ decision regarding Order 60 necessarily mean that the answer to this issue is that the declarations of the returning officers as made pursuant to Section 84 have been overtaken by events whereby GECOM, in its wisdom, considered that there were difficulties that had to be addressed in order to produce what is termed in Order 60 as a credible count. In this regard, difficulties have arisen subsequent to the declarations made, and Order 60 was meant to address them, and in this regard cannot be said to have retrospective effect. As noted by the Court of Appeal at paragraph 109 of Moore, it is within GECOM's functions to resolve those controversies as part of its responsibilities to deliver results of the elections. As noted earlier, the CCJ stated in paragraph 38 of Ali that the intention of Order 60 was to provide an open, transparent, and accountable recount of all the votes cast in those elections, end quote. It is in this context that Section 18 of the Elections Laws Amendment Act has to be read. This section states, I quote, "The Chief Election Officer shall, notwithstanding anything in any written law, be subject to the direction and control of the Commission." The fact remains that the circumstances surrounding the declaration of the results of the March 2, 2020 elections are contextual. As just concluded, given the decisions of the Court of Appeal and the CCJ, the recount cannot be considered to be invalidated, at least not at this point in time. In this context, the Section 84.1 declarations can no longer be considered useful. Hence, while the CEO may be expected to act independently, he cannot be a lone ranger, so to speak. I agree with the submission that Article 172(2)(b) can be construed to mean that GECOM is not to act on the advice of any person or body external to the Commission. I do not agree with the submission that the CEO has a constitutional mandate under Article 177(2)(b). It is the chairperson and GECOM that have the constitutional mandate. The CEO is a functionary of GECOM pursuant to Article 161A and Sections 2 and 7 of the RPA. Section 18, which is repeated in Order 60, merely confirms this and the obvious for the avoidance of doubt that the CEO cannot act on his own. In this regard, he has certain duties as regards tabulating results as provided for in Section 96 of the RPA. Section 18 is therefore not unconstitutional as being in conflict or in tension with Article 177. And as noted earlier, the CCJ also stated in paragraph 41 that any allegations as alluded to by the CEO can be addressed by way of election petition. If it is the considered opinion of the CEO that in the face of Order 60, he can produce a report based on the Section 84 declarations, then one would expect that he must be guided accordingly by GECOM. This, the evidence discloses, the chairperson has sought to do via the letters transmitted to the CEO. Thus, as determined by the CCJ, unless overturned by a court in an election petition, the only data that could be used for the declaration of the results of the elections would have to be the recount results or data. For the reasons outlined, the 10 declarations cannot be resurrected at this point in time. In this regard, there can no longer be an impasse between the chairperson and the CEO as to the effect of Article 177(2)(b) and Section 96. For the avoidance of doubt, as stated in Section 18, the CEO is subject to the direction and control of the Commission. In this regard, I refer to paragraph 14 of the CCJ judgment, where it is noted that by Section 18, the CEO is, quote, mandated to be subject to the direction and control of the Commission. Now to the final issue, whether these issues are res judicata given the decisions of the Court of Appeal in Moore and of the CCJ in Ali. In light of the discussion above, the decisions of the Court of Appeal and the CCJ have guided me in answering the issues that have arisen as a consequence of the 28 claims for relief sought by the applicant. Apart from Section 22, which was specifically cited, there are a number of the reliefs claimed in this application, which were claimed in or mirrored in the claims in Moore, and which I consider cannot be relitigated. Some of these were highlighted in the submissions for the 10th added respondent. It can be seen that the relief sought at Roman 5 and 6 in this application replicate those in Roman 4 and 6 of Moore. Paragraph 19 is exactly the same as paragraph 7. Paragraph 20 is mirrored in paragraph 9. Paragraph 21 is seen in paragraph 10. And paragraph 23 is similar to paragraph 11. Indeed, although couched in different terms, this application for the most part mirrors that in Moore, and in effect is similar to that of Ms. David in the Ali case. Res judicata is a legal principle that speaks to ensuring finality in litigation. As explained in Halsbury's Laws 5th edition, volume 12, Civil Procedure at paragraph 1168 et seq. The doctrine of res judicata applies where a matter has been adjudicated on by a competent court so that the matter cannot be relitigated. The principle can take different forms: estoppel by record, cause of action estoppel, and issue estoppel. Importantly, as submitted by the chairperson and added respondents, one has to consider that this application and that in Moore, as well as Holidar before them, are public interest litigation. Thus, such cases do not fall into the traditional criteria required to determine whether res judicata applies. The traditional formulation was confirmed by the CCJ in Garraway and Williams. Public interest litigation affects the public at large. While it has to be instituted by a person, the litigation should not be considered to be in personam or between or determining the rights of the parties thereto. It should be considered to be in rem, that is, leading to a determination of the status of a person or thing, or the disposition of a thing as distinct from a particular interest in it of a party to the litigation. And importantly, as highlighted in the submissions, the CEO was a party in Moore, Ali, and is a party in this case. Whether he participated in the proceedings or not, he is bound by the decisions in Moore and Ali. Also in Halsbury's Laws, 5th edition at volume 12 at paragraph 1182, the extent to which issue estoppel can apply to public law proceedings is discussed, though the context of the learning suggests its application may be limited. In my view, and I so hold, where there is public interest litigation, such as this application, barring a new issue arising or one that can be distinguished, or a claim that the judgment was improperly obtained, for example, through a misrepresentation of facts or law, or the perpetration of a fraud on the court, an applicant is bound by the decision on any issue that has been raised and adjudicated on previously. There must be finality to judicial decisions. Myriad persons cannot be permitted to engage with multiple applications regarding the same issue which has been decided and shield behind the claim that they were not a party to the previous proceedings. To so permit would be to waste precious judicial time and resources. In short order, this cannot be allowed. Rahman, the Chief Elections Officer, FDA 1151 of 2019 was a public interest litigation case, which required an interpretation of the CCJ decision in the consolidated appeals of Rahman, the Attorney General, Jack Dion, the Attorney General, and Passard and Reed. I applied the principle of issue estoppel in holding that the CCJ did not make an order that referred to or included a date or period for the holding of elections following the successful no confidence motion. As such, apart from applying the doctrine of stare decisis, I concluded that res judicata applied to the claim by Mr. Ram, and he was bound by the decision of the CCJ in this regard. The reliefs sought are all based on issues that have been litigated previously and determined by courts that take precedence over this court. Apart from res judicata, under the common law system, applying the principle of stare decisis, I am bound to follow the decisions of the Court of Appeal and ultimately the apex court, the CCJ. The application is accordingly dismissed. I have been lenient in the award of costs in what I call national interest matters, since I have considered them important for the development of our jurisprudence, more especially our constitutional jurisprudence. However, on this occasion, having found that the issues have led to a determination, having found that the issues that have led to a determination of this case have been decided by superior courts, the issue of costs has to be addressed differently. So unless counsel agree to costs, I will invite submissions on costs to be filed and served by all parties by email on or before July the 24th, 2020 for issuance of a cost order thereafter. That is the judgment of the court.
Much obliged, Your Honor.
Good for you.
Thank you very much, Your Honor.
May it please, Your Honor. May it please, Your Honor.
Sorry, yes, Mr. Ford.
Thank you, Your Honor. Your Honor, we are grateful for your decision, Your Honor, and your time and your legal expertise that is reflected in the judgment. Your Honor, would, as you've said in your closing remarks, Your Honor, that this case and the issues raise substantial issues of constitutional importance and of importance to the nation as a whole. In the circumstances, Your Honor, whilst we are not required to seek the court's leave to appeal to the Court of Appeal under Article 133. Your Honor, we wish to inform the court and the parties that we intend to so file an appeal to the Court of Appeal. Your Honor, at the commencement of the matter, I believe the Chief Elections Officer and the Chairman had given undertakings not to act in any way that would affect the outcome of Your Honor's decision or to affect the issues as far as I recall. I may not have gotten it precisely correct because sometimes the signal goes and comes, Your Honor. But substantially, Your Honor, I'm asking that the two respondents that I refer to, the Chief Elections Officer and the Chairman of the Elections Commission, do have their undertakings continued, until the hearing and determination of the appeal to the Court of Appeal, and by way of further information for consideration, Your Honor, we intend to file the appeal no later than the end of tomorrow, Your Honor.
Well, I don't know what Ms. Kite has to say on this issue. The CEO gave no undertaking, Mr. Ford. It was Ms. Kite who gave that undertaking on behalf of the chairperson of GECOM.
If I may, Devendra Kissoon, perhaps the issue of a stay would be better canvassed upon the filing of an appeal. And without an appeal being before the court, it's very difficult for any party to engage in any discussion concerning a stay. And I'm certain...
Well, Mr. Kissoon, I know that Mr. Ford did not ask for a stay, at least I'm not reading it that way. He is asking for undertakings to be given by, at least that's how I'm understanding him. He is asking for undertakings to be given by the CEO,
She can give it.
the chairperson. I was indicating to the chair that the CEO did not give any undertaking in this matter. It was only the chairperson who did.
Certainly, Your Honor. All I'm suggesting is perhaps that consideration would be better suited upon the filing of the appeal.
Please, Your Honor, might I support the application by Mr. Ford, if only for the fact that it has been the established practice of the chairman of GECOM, that once we have indicated clearly that we intend to see it in relation to issues that are germane for the entire country, and perhaps for the future of this country, that the court would say so, and I believe that once we indicated, and everyone has indicated that they'll go to the these issues. In fact, my friend Mr. Rankaran, in the matter before the CCJ, had indicated that he predicted that the matter would be back before them shortly. So I believe in other circumstances, no lawyer involved in this matter should be afraid to let the matter be finally ventilated at the CCJ era. I think that's what Mr. Ford is alluding to, the practice. And Ms. Kite actually confirmed it.
Your Honor, Mr. Williams is obviously putting words in Ms. Kite's mouth. All the undertakings that have been given so far were given at the time when there were extant proceedings pending. Now, with Your Honor's ruling, until an appeal is filed, there are no proceedings pending. And Your Honor, you did make an emphatic assertion about finality of litigation. But of course, if there is any right to be exercised for the purposes of an appeal, an application at that court should be made at the appropriate time, but not in vacuum. Any undertaking that's going to be given now would have nothing to be hinged upon, and it will be vacuous. It will be improper for any such undertaking to be given by any party at this stage of the proceedings.
Your Honor, I don't believe that it would be improper for an undertaking to be given, having regard to the nature of the issues
Well, Mr. Ford, it would be for Ms. Kite to indicate. I don't know that you could instruct her, tell her that she must give that undertaking.
No, I don't intend to do that, Your Honor. And that is what I was going to say next. That I noticed, apart from the Attorney General, a number of statements being made by counsel, other than that, representing the Chief Elections Officer, whom I'm asking that an undertaking be given from him, and the Chairman of the Elections Commission. For some moment, I believe that Mr. Nandalal was probably representing all of them now.
Yes, let me hear from Ms. Who is first? From Ms. Kite?
In respect to the undertaking, I believe so far in all these matters, my client has been conducting herself, as I indicated to the court, in a particular manner. If indeed the appeal will be filed by tomorrow, we will continue acting. My clients can undertake, if the appeal is filed by tomorrow, to continue to extend that same courtesy. The problem that we have here is that nothing is before the court as yet. So therein lies the difficulty. However, what we can undertake at this stage is that if by tomorrow the appeal is filed, then of course my client will continue to extend the same courtesy. Bearing in mind, Your Honor, that these elections were held since 2nd March, and we cannot continue like this. However, if once indeed Mr. Ford ensures that the appeal is filed by tomorrow, then of course my client can stay her hand. Without that, Your Honor, we can't say anything else because nothing has been filed as yet. We have to be fair to the nation.
Appreciated, Ms. Kite. I don't know if Mr. Boston has anything to say.
Adopt the same position as Ms. Kite.
Very well. Good, thank you very much. And I only discerned 2 small typos when I was reading the judgment. So if anything, you may get the 2 pages that have the typos. But other than that, the judgment is perfected and it will be emailed to you shortly.
Thank you.
Very good.
Thank you very much. Have a good